These regulatory bodies exercise various powers granted to them by the legislature by virtue of the provisions in Article 19 and other articles. I am not very sure about knowledge about Article 19, but I will just mention. Article 19 has 5 clauses which mentions the basic rights: right to carry on business, right to carry on profession, right to establish institutions, right to move and all the rights, right to media, freedom of expression, all these are contained in Article 19. Because Article 29, 30 also the minorities' rights to establish education and institutions. Now Article 96 is important. Article 96 says is that all these rights can be exercised by the citizens, but only subject to such reasonable restrictions as may be made by. So the law can bring about restrictions on all these rights of individuals, associations, bodies, media, etc. You must note the word law in Article 96. The very important significance is these fundamental rights cannot be restricted by executive action alone unless the executive action is traceable to a law made by the legislature. Maybe a law made by Parliament, or it may be a law made by state legislature. Unless the legislature, which is a higher superior body, the representative people, they may take policy decisions, they know how far to restrict the fundamental rights. So it must be a law made by Parliament. Now that law will regulate these fundamental rights. While making the law may say that some powers will be exercised in the executive. That is called delegated legislation. That is to say, the legislature enables the executive to also exercise these regulatory powers, but all delegated powers have to be exercised within the scope of the delegation. If the executive exceeds its powers granted to it under the legislation, again that action will be ultra-virus. So this is the broad framework. No fundamental right in Article 19 can be abridged except by law. That's first thing. Second thing is, the restriction must be reasonable. Reasonable with the objective sought to be achieved. Some deal with public interest, some deal with public order, some deal with morality, and so on and so on. Now media rights, media can't do everything. You can pass a law about obscenity, you can regulate the cinema, you can regulate the other types of media. The law can be passed. So by law you can restrict the right of freedom of expression. Now what is reasonable? Who will decide whether it is reasonable? That the reasonableness of the restriction imposed by the legislature on the fundamental rights, that reasonableness will be decided only by the judiciary, that is the constitutional courts, that is the High Court and the Supreme Court. So the separation of powers doctrine is embedded in this. Now the Constitution contains one division relating to legislature, one relating to the executive, and the judiciary. It is stated that the American Constitution makes a very rigid separation of powers, but the Indian Constitution does not make a very rigid separation of powers. So there is chance of one branch trespassing into the other branch. But how far it can do is again ultimately the final authority is judiciary. Even in the United States, the politicians criticize these 9 people will decide the fate of this country. There all the 9 leaders decide together. So the judiciary is the ultimate arbiter on the reasonableness of the restrictions imposed by the Constitution. this is called what is meant by judicial review. Judicial review doctrine, that is the power of the judiciary to review the reasonableness of the restrictions imposed by the legislature or the action of the executive. That is the power of judicial review. That is enshrined in two articles of the Constitution. One is Article 226, under which the High Court exercises power, and in Article 32, under which the Supreme Court exercises the power of judicial review. Apart from judicial review of legislative action and executive action, these courts can also issue writs of mandamus directing them to obey and implement the statutes that have been made, insofar as they are concerned. So various powers are conferred on the judiciary. But the legislature cannot take away the powers of the judiciary. That is because of the separation of powers. Now in the Constitution, you know, there are three lists. One is the union list, another is the state list, another is the concurrent list, on which the Parliament can make laws. Parliament can make laws on those subjects. Of course, it has a residuary power to legislation. States' powers are enumerated. In the concurrent list, both Parliament and states can legislate, but the legislation made by Parliament will override any concurrent legislation made on the subject by the state legislature, provided the state legislation is submitted to the President for the assent. That is, if the central executive will assent, then the state legislation can override the central legislation. There are some very limited articles under which Parliament can make a law even in respect to matters in the state list. And that's a very limited area. That's where the environmental law comes into being. There is one article which says that if any legislation is made by Parliament in regard to certain discussions or decisions made in international conferences or treaties, then the Parliament can legislate even on the state subjects. That is how the Water Act and the Air Act, all come in. Though part of them are the state subjects, Parliament has taken over the power because of the Rio Conference is quoted in the Payables when they say we assume powers and consequences. Even this nuclear treaty also is under, they say that opposite party say you want to discuss in Parliament or make a law, but they say treaty powers are with us, we can do it without going for legislation. That's a separate thing. Now, the executive has the duty to implement the laws. There are occasions when the executive itself makes laws which the legislature has to make, and then the executive's orders may be struck down. But here, take one thing. There are two articles in the Constitution which say that the executive power extends to all the subjects on which legislation can be made. So supposing the executive of the central government, central bureaucracy, they can pass any executive order provided it is referable to those subjects on which Parliament can make laws. Similarly, the state executive can make executive orders on all subjects which are within the purview of the state legislature. The only exception is where executive action cannot survive by itself is where reasonable restrictions are imposed on the fundamental rights in Article 19. It is only the legislature that can do, executive cannot do it by itself. That's the scope of the exercise of powers. Now, the great principle of judicial review of legislative action, whether an act made by the legislature is within the Constitution or not. Supposing the restriction made by the legislature is not reasonable, the court will strike down that law. Supposing there is a restriction on newspapers beyond what is permissible, then the restriction will be struck down by the court, that law will be struck down. Now, what is the origin of this power of the court for judicial review? The first case on judicial review is a famous case in the American Supreme Court, what is known as Nursery versus Madison. In that, Chief Justice Marshall first laid down the principle of adjudication by the judiciary as to whether any legislation is within the scope of Constitution or not. Now that principle has slowly been adopted in various countries where there is a written constitution or where there is separation of powers. But see the very anomaly here, the Indian courts are allowed to strike down legislation as being contrary to Constitution or executive action either being contrary to the legislation or to contrary to Constitution. The courts can do it. But the British courts in England and American courts also can strike down legislation. Judicial level is very wide. But in England, where parliamentary sovereignty has always been accepted as supreme, they have not been so far able to give grant powers to the court to strike down any law. In England, the European Convention has been accepted in 1950. It contains the same fundamental rights as we have. Most of them are same, language is the same. But they can't do anything. In the House of Lords can't strike down any law. Now there is also an appeal to the European Court in Strasbourg over the House of Lords. And they may say something, but English courts can't do anything. Now in 1998, the United Kingdom's Human Rights Act has come into force. It has come into force on 2nd October 2000. But even that law says that the English courts can only declare that the law is not in consonance with the European Convention, but it can't strike down the law. If they really point out the defect in the law but can't strike it down, it will be for Parliament to make changes. This is the position in New Zealand and Canada also. There are various concepts of judicial review within the scope of separation of powers. Now, sometimes the legislature steps in and tries to take away the powers of the courts. In the regulatory mechanism, for example, it started with the trial. The trial started exercising judicial powers. Then it was objected to, matter went to Supreme Court. The same thing happened to say the Competition Commission also, same problem was there. These commissions are manned by bureaucrats, and there are disputes between government or a telecom company or between two telecom companies. Then the trial started also adjudicating and not really laying down the policy for telecommunication. The Supreme Court said you can't do it. Then they established the Telecom Appellate Dispute Tribunal with a retired Supreme Court judge as a member and two other members. The same thing has happened for the SEBI, there is an appellate authority, which is presided either by a Supreme Court judge or a retired Chief Justice. The Competition Commission, they appointed the Commerce Secretary as chairman, the Supreme Court said no. As far as judicial functions are concerned, now they have made provision and Justice recently administered. Justice Pasna has been appointed and the Competition Commission. So like this, wherever the regulatory framework was not really concerned with the executive policies, but it was also trying to take over adjudicative powers, the courts have objected and said adjudicative powers must be only by a judicial body. Now what is the great thing about the judicial body is, now judges who are appointed in law, they might have practiced for a long time in the courts, they have a judicial mind, they observe principles of natural justice, and they give legal judgments which are public documents. Now you find members of the executive, they pass orders, several orders to the government, both central and state, we are very familiar. The government is opinion, this is to be done, that is to be done. Or it is no reason to do this or no reason to do that. Only one side there is no reason to be given. And several follows a fair procedure, gives reasons, and his father's orders consistent with natural justice, in the judiciary there are appeals to correct the same matter of the High Court. Now, after the Parliament committee said the High Court, then we started having the administrative tribunals dealing with service matter disputes between employees and the state, matters of promotion, dismissals and so on. Seniority, they were all sent to the administrative tribunals. There is a central administrative tribunal for central services, state administrative tribunal for the state services in different states. But against these tribunals, before these tribunals were formed, all these matters are being granted by the High Court. High Court had a lot of other work, criminal work, civil work, completely shook them out of the court to the section was issued. Against the judgment of the tribunals, initially, appeals were directly going to the Supreme Court. The orders of the tribunals and the High Courts were relieved of this problem. But then the Supreme Court decided in Chandra Kumar's case, which Prof. Anant has discussed. In Chandra Kumar, a very important principle was laid down that the power of the High Court of judicial review under Article 226 and the power of the Supreme Court under Article 32 of judicial review of legislation or executive action, this is a basic feature of the Constitution. A basic feature, basic structure of the Constitution, in the case of the case, the Supreme Court said that you can't change it even by amendment to the Constitution. There are certain basic features of the Constitution which cannot be altered even by Parliament in its amendatory process of Article 363. So the Supreme Court said that all things have started going to the High Court. Now High Courts are now having to have at least one or two benches dealing only with service matters, appeals coming from central tribunal and state tribunal. But dealing with matters at an appellate stage is somewhat different from dealing with them as an original court, where the pleadings have been filed and so on has to be done. That will shorten the litigation, but it has not solved the problem of arrears. However, it has only increased. So, fed up with this, the Madhya Pradesh government abolished the state administrative tribunal, and several states want to abolish because they are having to have as many judges in High Court. If the Constitutional Tribunal is not going to reduce the independence in High Court, so they abolish the Constitutional Tribunal. So that's a separate issue. Now there is another method by which the legislature started interpreting the finality orders. So long back, even in England, the Act would say an order will be passed by a Tahsildar and then appeal to a deputy collector, then that order will be further appeal to a collector or some board of revenue. That order will be final. The finality, court says that finality is only within the hierarchy of the tribunals. It will not affect the powers of the courts. Now this was taken to a logical extent. You know, under the legislature, when members of the legislature jump from one party to another party, there is a disqualification. Unless it is more than 1/3 or half, then some rules are there. They must go out as a group. When individual goes, he gets disqualified. Now on this disqualification, the speaker gives a ruling under the Constitution. The Constitution said that the regional speaker is final, but Supreme Court said it is not final, we will further review it. There are several instances in which orders of disqualification made by speakers have been satisfied with Supreme Court. Because you know that the ruling party's one elected representative generally becomes a speaker, and there are many instances of bias on the part of the speakers in disqualifying or not disqualifying some members who are defective. So ultimately the power remains with the court. So this is broadly the principle of separation of powers. So one of the important things is the judiciary, and no doubt under the drafters, judicial review has taken over both to review legislation and executive action. So it was thought that the judiciary is receiving more powers than it ought to take. But the judiciary's powers are curtailed by not granting enough funds to the judiciary to function, to clear its areas and redress the grievances and disagreements. So there is a famous quotation by one of the American legislators: the judiciary does not have the purse, not the sword. It has no power of implementing its orders. It has to depend on the executive. It can't establish courts because it doesn't have the money. So there are, I was just part in a committee on judicial impact assessment, where we have reviewed this position. There are instances where American judges have gone to court and filed a case for getting funds to the judiciary. So they developed a new doctrine, and the doctrine of separate powers requires that each wing, the legislature and the executive and the judiciary, should not act in a manner which precludes the other wing from functioning properly. Now, by denying funds to the judiciary, the legislature and the executive may cripple this institution. So they laid down a principle like that we have to give sufficient funds to the judiciary also. That's a financial aspect. Now, to take the subordinate judiciary in India, that is the civil judges, the criminal courts, which are all working under the High Court. The greatness of our constitution is that under Article 239, the entire supervision of the subordinate court is vested in the High Court. Now the magistrate has to be transferred, the civil judge has to be transferred, promoted. It is not the chief minister or any minister or law minister that has anything to do with it. They have absolutely no role. The entire power of appointment, promotion, transfer, discipline action of all the subordinate judiciary, both civil and criminal, is vested in the High Court, and the executive is kept away totally. It is the greatness of the independence of the judiciary, and Supreme Court has said the independent judiciary is also part of the basic structure of the Constitution. Now coming to judicial activism. Now while these powers of legislature, executive and judiciary remain separate under the Constitution, the judiciary started in recent times exercising extraordinary powers under the public interest litigation. They say you lay down a road there, you construct a bridge there,